When elephants and wild boars cross paths with farmers, it's more than a wildlife conflict, it's a governance test. Kerala's amendment to the Wildlife Protection Act, 1972 has opened a fresh debate between federal autonomy and national environmental safeguards. The TeachTrick UPSC model breaks down how this new law could redefine the center-state balance in wildlife governance and why it matters for India's biodiversity commitments. The Hindu editorial explanation, Tusks and tensions. Kerala's changes to Wildlife Act will devolve national safeguards. Background: the Wildlife Protection Act, 1972 is India's cornerstone legislation for the conservation of wild animals, plants, and habitats. It classifies species into Schedules I to V, granting varying levels of protection. Under Section 62, the central government can declare certain wild animals as vermin, thereby removing their legal protection temporarily in specific areas. Kerala has witnessed increasing human-wildlife conflict, particularly involving wild boars, leading to loss of life, crop damage, and community protests. Frustrated with the centre's inaction to declare wild boars as vermin, Kerala has proposed the Wildlife Protection Kerala Amendment Bill 2025 to empower itself to take such decisions independently. Main news, core analysis, what the Kerala Amendment seeks. 1. State power to declare vermin allows Kerala to decide when an animal listed under Schedule 2 can be classified as vermin for specific areas and periods, currently a union power. 2. Enhanced authority to Chief Wildlife Warden authorizes the warden to order capture, translocation, or killing of animals that injure humans. 3. Local control over human-wildlife conflicts aims to reduce bureaucratic delays in responding to wildlife attacks. Why Kerala is pushing for change. Frequent wild boar attacks have led to crop losses and human deaths. Centre's refusal or delay in declaring vermin under Section 62 of the Central Act. Political pressure from affected farming communities. Analysis 1. Federal friction. Wildlife lies in the concurrent list, List 3, both center and states can legislate. However, any state law inconsistent with a central law requires presidential assent, Article 254. Kerala's move challenges the balance of environmental governance in India. 2. Risk of diluting safeguards. The amendment could set a precedent for other states to downgrade protections for politically sensitive species. Without national oversight, indiscriminate culling could erode India's conservation baselines. 3. Conservation versus coexistence. The root issue lies in human expansion into forest buffer zones, not animal aggression. Declaring animals as vermin risks treating symptoms, not causes. Need for coexistence strategies, fencing, compensation, and crop protection insurance. Conclusion, solution explanation. Kerala's move reflects real pain, farmers' lives and livelihoods are at risk. But federal shortcuts cannot replace systemic reforms. Checkmark balanced way forward. 1. Preserve national baselines, do not dilute the central safeguards of the Wildlife Act. 2. Develop state-level ceilings, faster, transparent decision-making with local accountability. 3. Promote non-lethal tools, tranquilization, relocation, and compensation-based coexistence. 4. Use scientific thresholds. Wildlife management must be based on data, not politics. 5. Reform center-state consultation process, periodic ecological reviews to prevent policy deadlocks. Devolution of power should not mean abdication of responsibility. Federalism must protect both people's rights and nature's rhythm. From elephants in Wayanad to wild boars in Konaseema, India's wildlife conflicts are rising. Kerala's new amendment to the Wildlife Protection Act gives the state the power to act, but at what cost? TeachTrick decodes the delicate balance between ecological prudence and federal autonomy, and why declaring an animal as vermin might be the most dangerous shortcut in wildlife governance.